I sat down for a conversation with Jason Allan from Allan Law, and one of the topics we discussed is estate planning for your family cottage. Specifically, the situation where you pass your cottage down to a child of yours, and that child's marriage eventually dissolves. What happens to that cottage asset? The answer might surprise you. And so, in this discussion, we talk about what can happen if you're not prepared and the things that you can do to prepare yourself for that scenario before the fact. And hopefully you enjoy this conversation. So I'll turn it over to my discussion with Jason Allan.
I think one of the important things to keep in mind with a cottage is to make sure your children know that there are family law implications to inheriting a cottage if they have a spouse. So, under the Family Law Act, which is the legislation that governs matrimonial relationships, um, inheritances are not shared with the spouse generally, provided there are certain exceptions to that. One of the exceptions is if the inheritance is invested in a matrimonial home or is a matrimonial home, which is, of course, any home that you're using with your spouse. So even though you may have a primary residence in Newmarket or Aurora,
Mm-hmm.
if you have a secondary residence that maybe you inherit from mom and dad and it's a cottage property, well, if you're using that cottage property with your spouse, it would be a matrimonial home, and the
Mm-hmm.
spouse would be entitled to half of it. And a lot of people are not aware of that. And I had a case where I was acting actually for the husband, and he separated from his wife, and she had inherited a cottage from her parents, which they, of course, were using together. And the husband had also received an inheritance, but his inheritance was left in his own bank account, right?
Mm-hmm.
And so when they separated, the wife was very upset and surprised to learn that her half of the cottage, the cottage that she had inherited, had to be shared equally with
Wow.
the husband, whereas his inheritance, which was left in his own bank account, did not have to be shared.
Wow.
So there are two exceptions to that inheritance rule. One is, of course, if it's money that's invested in a matrimonial home or is a matrimonial home, which can be more than one property.
Mm-hmm.
Or secondly, if the money is commingled. So if you get an inheritance and you put it into a joint account with your spouse, well, then that money would have to be shared if you subsequently separate. So I think those are some important things to keep in mind with cottage properties, is really making sure that your children are aware that if they intend to keep the cottage that they inherit and they intend to use it with their spouse, that might be something they want to address in a domestic agreement with their spouse. So the way around that would be, well, either you trust that your spouse isn't going to make a claim against the cottage if you
Right.
separate, but
Right.
sometimes what you expect to be the case may not actually be the case
Mm-hmm.
after you separate. So those understood expectations may not necessarily materialize when there's a
Yeah.
separation.
Yeah.
So it might not be a bad idea if if you've inherited a cottage property and that
Mm-hmm.
you keep in use with your spouse, to have a written agreement which acknowledges that maybe even the only the increase in growth and value of the property will be shared, right? So either the
Mm-hmm.
cottage will be kept separate from any division of family law assets.
Yeah.
Maybe the people want to agree that the cottage was worth $1 million when it was inherited,
Mm-hmm.
but since the spouses are going to be investing in the property in the future and want to share in that property, that at least the initial inherited value is kept separate from the division of assets, and
Mm-hmm.
the increase in growth and value is shared.
Is there anything that can be done with, let's say, the parents, like mom and dad own the cottage, it's going to get passed down to their child, and then potentially have this issue with the child's spouse, right? Is there anything that the parents can do proactively before that cottage is passed down to the child? Is there anything they can do in their estate planning to make sure that they protect that asset from their child getting separated or divorced down the road?
Well, there are things like trust agreements that
Yeah.
can be considered, and that might be the subject for a whole other
Yeah.
podcast interview.
Using
Um,
trust. Yeah.
I think the one basic thing is just to make sure that the child knows that if they intend to use the property with their spouse, that they're exposing themselves to the potential of having to share that property equally with their spouse.
Mm-hmm.
And if that's their decision, then perhaps so be it, but at least they've been made aware of that.